So we are now on law enforcement and rule of law, and this discussion is focused on arrest. So it's very important that we should define arrest. So arrest is taking a person into a custody in order that he may bound to answer for the commission of an offense, and it is stated in Rule 113 under Rules of Court. So basically, this action is undertaken for the purpose of holding the individual accountable for the commission of an offense. And the arrested person is bound to answer the allegations brought against them through formal legal proceedings. No violence or unnecessary force shall be used in making an arrest, and the person arrested shall not be subject to a greater restraint than is necessary for his detention. And here's a question: what is the importance of arrest in the administration of criminal justice system? So we all know that if the accused is not arrested, the court will not acquire jurisdiction over his person unless the person surrenders himself to the authorities. So basically, it's important because the court cannot proceed with the trial of the person without his presence. And if a crime is undetected or unreported, it is obviously does not enter the system. And even if it was already committed but it is still undiscovered, it does not enter the system. And how is arrest made? So an arrest is made by an actual restraint of a person to be arrested or by his submission to the custody of the person making the arrest. So this statement outlines two primary ways in which arrest can occur: by the actual restraint of a person by the arresting authority, or by individual willingly submitting to the custody of the person making the arrest. So next one is, there are two forms of arrest. We have the first one, the warrant of arrest, and the second one is warrantless arrest. And when we say warrant of arrest, it's the written authority of the arresting officer when making an arrest or taking of a person into custody in order that he may be bound to answer to the commission of an offense. So when we say warrant of arrest, it is a legal document issued by a judge that grants law enforcement the power to arrest or take a person into custody. This is based on evidence or information presented to the court, demonstrating probable cause to believe that the individual has committed an offense. And the document typically specifies the person to be arrested, the alleged offense, and in some cases, the time and place where the arrest may occur. And here's a question: how is warrant executed? So this is, we can see this one on section 4 of Rule 113. So that talks about the execution of warrant. So the head of office to whom the warrant of arrest has been delivered for implementation shall cause the warrant to be implemented within 10 days from receipt. So according to this provision, when a warrant of arrest is delivered to the head of office, that official is mandated to ensure the warrant's implementation within a specified period of 10 days from the date of receipt. So this requirement emphasizes the importance of a timely and efficient execution of arrest warrants, preventing unnecessary delays in the apprehension of individuals accused of offenses. And here are the general guidelines when it comes to arrest. We have here the first one: all arrests should be made only on the basis of a valid warrant of arrest issued by a competent authority. except in instances where the law allows warrantless arrest. So general rule when it comes to arrest, all arrests should ideally be conducted based on a valid warrant of arrest issued by a competent authority, which is the judge. And this requirement seeks to safeguard individual liberties by ensuring that arrests are grounded in legal authorization, supported by evidence presented to a court or judge. And the second one here, no violence or unnecessary force shall be used in making an arrest, and the person to be arrested shall not be subjected to any greater restraint than what is necessary under these circumstances. This second one, it emphasizes that arrest should be carried out without resorting to violence or unnecessary force, aiming to safeguard individual rights and prevent abuses of power. Law enforcement must exercise restraint and use only the minimum force required under the circumstances. And we have here the third, fourth, and fifth general guidelines. For the third one, as a general rule, arrest can be made on any day of the week and at any time of the day or night. So law enforcement must carry out their duties and respond promptly to situations requiring immediate action. So it recognizes that criminal activities and the need for arrest can occur at any time. And the law enforcement officers must have the authority to act swiftly and without unnecessary delay to maintain public safety. And the fourth one, only judges are authorized to issue warrants of arrest. So only judges are authorized to issue warrants of arrest. It ensures an independent and impartial review of the evidence before authorizing an arrest. And for the fifth one, a warrant of arrest is no longer needed if the accused is already under detention. An order of commitment is issued by the judge in lieu of the warrant of arrest. So on the fifth one, if an individual is already in custody, a new warrant is not necessary. Instead, the judge can issue an order of commitment formalizing the detainee's continued confinement. Person immune from arrest. So we have two here. A senator or member of the House of Representatives while the Congress is in session for an offense punishable by not more than 6 years of imprisonment. And second is diplomatic agents under the Vienna Convention and diplomatic relations. So on the first one, when we say being in session, it refers to when Congress is meeting during the session. Our Constitution actually provides that our Congress convenes for its regular session every year. So that begins on the 4th Monday of July. And the first one, the statement basically suggests that during the time when Congress is in session, the senators or members of the House of Representatives may be immune from arrest for offenses punishable by not more than 6 years of imprisonment. This immunity is granted to ensure that lawmakers can perform their legislative duties without the threat of arrest or detention, allowing them to participate in debates, discussions, and decision-making process without interruptions. However, it's important to note that this immunity is usually limited to offenses with a relatively lower penalty. And on the second one, the Vienna Convention on Diplomatic Relation, it's actually an international treaty that outlines the rules governing diplomatic relations between sovereign states. And diplomatic agents, these are representatives of one country to another. So they are afforded certain privileges and immunities under Vienna Convention. So one of the key immunities is protection from arrest or detention. So they are generally immune from arrest, criminal jurisdiction, and civil suits in the host country, ensuring that they can carry out their diplomatic functions without fear of interference. And we have a question here. What is the duty of the arresting officer? So we have here an image. Yeah. So this one is a police station. So to answer the question, it's stated on Section 3, Rule 113, that it shall be the duty of the officer executing the warrant to arrest the accused and to deliver him to the nearest police station or jail without unnecessary delay. And when it comes to the method of arrest by officer, by virtue of warrant, the general rule is that when we are effecting an arrest, there should be a document, a warrant of arrest. So when it comes to the method of arresting an offender, the officer shall inform the person to be arrested of the cause of the arrest and of the fact that the warrant has been issued for arrest, except when he flees or forcibly resists before the officer has the opportunity to so inform him, or when the giving of such information will imperil the arrest. So the officer need not have the warrant in his possession at the time of the arrest. But after the arrest, if a person arrested so requires, the warrant shall be shown to him as soon as practicable. And what is the time of making arrests? So we have discussed this previously, and that is, so I don't know what happened. An arrest may be made on any day and at any time of the day or night. And we have another question. What is the method of arrest by officer by virtue of warrant? So I've discussed that previously. And the basis of this is the Section 7 of Rule 113. So as what I've said, the officer shall inform the person to be arrested of the cause of the arrest and the fact that the warrant has been issued for his arrest. Yan. Okay. Bayan. So the officer need not have the warrant in his possession at the time of arrest, but after the arrest, if the person arrested so requires, the warrant shall be shown to him as soon as practicable. So there is also an exception here that if ever the offender flees or forcibly resists before the officer has the opportunity to so inform him, or when the giving of such information will imperil the arrest. So the telling of the cause of the arrest and the fact that the warrant has been issued may be done by the officer later. And we have here the citizen's arrest. So it's a warrantless arrest that can be effected by a private individual. It is termed as a citizen's arrest if arrest is made by a private individual or citizen. So this citizen's arrest, it is on Section 9 of Rule 113. So if a private individual or person makes an arrest, he or she should inform the officer, the offender, to be arrested of the intention to arrest him, what is the cause of the arrest, unless the person to be arrested is then engaged in the commission of an offense or is pursued immediately after its commission, or after an escape, or flees or forcibly resists before the person making the arrest has opportunities to inform him, or when the giving of such information will imperil the arrest. So basically, to simplify things, citizen's arrest, that is the ability of a private individual who is not a law enforcement officer to make an arrest without a warrant. So in certain situations, we all know that individuals may find themselves witnessing a crime or personally aware of a criminal act. So if these circumstances meet specific legal criteria, a private citizen may have the authority to detain the alleged wrongdoer until law enforcement arrives or to bring them directly to the police. And we have here the alias warrant. It is a second writ of execution replacing the first one due to expiration. The court shall issue an alias warrant if the original warrant of arrest is returned by the peace officer together with the report. So this document typically arises when the original warrant of arrest is returned by the peace officer unexecuted, accompanied by a report detailing the reason for its non-execution. Because when we say alias, it denotes that it is an alternative or substitute warrant providing law enforcement with a renewed opportunity to carry out the arrest based on the same charges specified in the original warrant. So we have here the John Doe warrant. So it is a warrant for the apprehension of a person whose true name is unknown. Generally, this kind of warrant is void because it violates the constitutional provision, which requires that warrant of arrest should particularly describe the person or persons to be arrested. But there is always an exception to the rule. So when is John Doe warrant valid? Or are they valid at all? So we've described what is John Doe warrant previously. And John Doe warrant can be valid if the best description possible is given in the arrest warrant. So how can we say that it is the best description? It must be sufficient to indicate clearly on whom it is to be served by stating his occupation, personal appearance or peculiarities, the place of residence, or other circumstances which may he identified. Yeah, if there is sufficient description. This is when the John Doe warrant can be valid. And we have here the three modes of warrantless arrest. So this is provided on section 5. Yeah, the first one is in flagrante delicto and hot pursuit rule, and the last one is escapee. So when we say a warrantless arrest, this is another form of arrest wherein it refers to the apprehension of an individual by a law enforcement without the necessity of obtaining a warrant from a court beforehand. While warrants are generally required to ensure judicial, oversight and protect individuals' rights, there are specific circumstances where law enforcement officers can make arrests without a warrant. And these are the three. Yeah, when we say in flagrante delicto, it is in the act of committing a crime or caught in the act. So it refers to a situation where a person is apprehended or observed in the actual process of committing a criminal offense. So in such cases, law enforcement officers are generally allowed to make a warrantless arrest because they directly witness the criminal act taking place, providing immediate justification for the apprehension. The second one is the hot pursuit rule. So when we say hot pursuit, the offender has just committed an offense. And on hot pursuit, when the offense has just been committed and he has probable cause to believe, based on personal knowledge of facts and circumstances, that the person to be arrested has committed it, so the law enforcement officer may arrest that person without a warrant. And the third one is escapee. So when the person to be arrested is a prisoner who has escaped from a penal establishment or a place where he is serving final judgment, or is temporarily confined while his case is pending, or has escaped while being transferred from one confinement to another, then the law enforcement officer need not to have that document, which is the warrant of arrest. And just to add up on hot pursuit, there general rule, there is really no need that we have the document, but the arresting officer, peace officer, private person, should have personal knowledge of facts, indicating that the person to be arrested has really committed it. And we have here a question: what are the prescribed hours for warrantless arrest? So we have to memorize this 12, 18, and 36. So yeah, this is the prescribed hours for us to deliver the offender to the right authorities. So for light penalties or its equivalent, we should deliver it within 12 hours. And if the offenses are punishable by correctional penalties or their equivalent, the offender should be delivered within 18 hours. And for afflictive penalties or their equivalent, the person should be delivered within 36 hours. And we have Here, the authority of the arresting officer when making an arrest. So that's provided as the first one, police officer may summon assistance. That's provided on section 10 of Rule 113. That an officer making a lawful arrest may orally summon as many persons as he deems necessary to assist him in effecting the arrest. So every person so summoned by an officer shall assist him in effecting the arrest when he can render such assistance without detriment to himself. The second one is right of a police officer to break into building or enclosure. So that is stated on section 11, which is about right of officer to break into building or enclosure. So an officer, in order to make an arrest, either by virtue of a warrant or without a warrant as provided in section 5, which is about warrantless arrest, the officer may break into any building or enclosure where the person to be arrested is or is reasonably believed to be. So if he is refused admittance thereto after announcing his authority and purpose. The third one is the arresting officer has the authority to break out from building or enclosure. So that's stated on section 12. Whenever an officer has entered the building or enclosure in accordance with the preceding section, he may break out therefrom when necessary to liberate himself. For the fourth one, arrest after escape or rescue. So that's stated on section 13. So if a person lawfully arrested escapes or is rescued, any person may immediately pursue or take him without a warrant at any time and in any place within the Philippines. So we have here the procedures in the conduct of arrest with warrant, meaning there is a document. So whenever we are serving the warrant of arrest, we need to verify the validity of the warrant and request for an authenticated copy from the issuing court. So the police officer must first verify the validity of the warrant and request this authenticated copy from issuing the court. Second one is upon confirming the warrant's legitimacy, the officer is required to introduce themselves. Shall introduce himself and show proper identification to the person being arrested. And the third one, following the introduction of the police officer for proper identification, the officer should make a clear manifestation of their authority, notifying the individual of their intention to carry out the arrest in accordance with the lawful warrant. And we have here the fourth one. If refused entry, the police officer may break into any residence, office building, and other structure where the person to be arrested is in or is reasonably believed to be in, after announcing his purpose. So the police officer needs not have a copy of the warrant in his possession at the time of the arrest. If a person is arrested or requires, the warrant shall be shown to the arrested person as soon as possible. So just to summarize the fourth and fifth one, in the course of serving a warrant of arrest, if entry to a residence or other structure is refused, the police officer is authorized to forcibly enter after announcing the purpose of entry. So it is not mandatory for the officer to have a physical copy of the warrant during arrest, but if requested by the arrested person, the warrant should be presented to them as soon as feasible or possible. No, so what is the main purpose? Why is it necessary to uphold the fourth and fifth one? It's to ensure that law enforcement officer can effectively carry out warranted arrest even in situations where entry is denied. It also recognizes the right of the arrested individual to be informed of the legal basis for the arrest in a timely manner. And we have here the sixth, seventh, and eighth ones. So for the sixth, secure the person to be arrested and use handcuffs for the protection of the arresting officer, other individuals, or the arrested person himself. Conduct thorough search for weapons and other illegal materials on the person arrested and surroundings within his immediate control. Inform the person to be arrested of his rights under the law. So, just to summarize, during the serving of a warrant of arrest, the police officer is required to secure the person to be arrested and may use handcuffs to ensure the safety of the arresting officer, other individuals, or the arrested person. So following the apprehension of offender, there should be a thorough search for weapons and other illegal materials within the immediate control of the arrested person and their surroundings is conducted. Subsequently, the person to be arrested must be informed of their rights under the law. So it is emphasized that no unnecessary force should be employed in making the arrest, highlighting the importance of conducting arrests with due regard for the protection of all individuals involved and in adherence to legal and ethical standards. And the ninth, no unnecessary force shall be used in making an arrest, of course. So we have here the 10th, 11th, 12th, 10th, confiscated evidence shall be properly documented with a chain of custody of evidence, duly and clearly established. Bring the arrested person to the police station for documentation. Make a return of warrant to the court of origin, and deliver the arrested person to jail/prison upon the issuance of a commitment order of a court. So, in the process of serving a warrant of arrest, it is crucial to properly document confiscated evidence, ensuring a clear and duly established chain of custody for legal purposes. Subsequently, the arrested person should be taken to the police station for documentation, and the police officer must then make a return of the warrant to the court of origin, providing an official account of the arrest process. Once the court issues a commitment order, the arrested person is to be delivered to the appropriate jail or prison facility. These steps are crucial, of course, for maintaining the integrity of the legal process, documenting evidence accurately, and ensuring a transparent and lawful transition of the arrested individual into the custody of the judicial system. And we have here the procedures in the conduct of arrest with warrant. So we are now on effecting warrantless arrest. So first one is to freeze or restrain the suspect, make proper introduction as to identity and authority to arrest, inform the arrested person of the circumstances of his arrest, and recite the Miranda warning and anti-torture warning to him, and secure the person to be arrested, and use handcuffs for the protection of the arresting officer, other individuals, or the arrested person himself. So in effecting a warrantless arrest, the law enforcement must first freeze or restrain the suspect, and the arresting officer is then required to make proper introduction, identifying themselves and establishing their authority to make the arrest. And the arrested person must be informed of the circumstances surrounding the arrest, and the arresting officer is obligated to recite the Miranda warning and the anti-torture warning to the individual. So, following the apprehension, it is necessary to secure the person being arrested, utilizing handcuffs, if needed for the protection of the arresting officer, other individuals, or the arrested person. So, the last slides that I have discussed, it's more on warrant of arrest. What are the procedures? But what we are talking right now, what are the procedures if it is a warrantless arrest? So we have here for the 5th, 6th, 7, and 8. So conduct thorough search for weapons and other illegal materials on the person arrested and surroundings within his immediate control. Confiscated evidence shall be properly documented with a chain of custody of evidence duly and clearly established. No unnecessary force shall be used in making an arrest, and bring the arrested person to the police station for further investigation and disposition. So just to summarize 5th up until 8th, so whenever we are effecting that warrantless arrest, the process includes conducting a thorough search for weapons and other illegal materials on the person arrested and within their immediate surroundings. And any confiscated evidence is required to be properly documented with a clear and duly established chain of custody for legal purposes. And emphasis is placed on avoiding unnecessary force during the arrest. Following the apprehension of the offender, the arrested person is delivered to the police station for further investigation and disposition, ensuring a systematic and lawful progression of the arrest procedure. And next is we have here, what are the duties of arresting officer? So it shall be the duty of the police officer implementing the warrant of arrest to deliver the arrested person without delay to the nearest police station or jail to record the fact of the arrest. So when a police officer is implementing a warrant of arrest, their responsibility is to promptly deliver the arrested person to the nearest police station or jail to officially document the arrest. And at the time of the arrest, it shall be the duty of the arresting officer to inform the person arrested of the cause of the arrest and the fact that a warrant had been issued for his arrest. The arresting officer need not have the warrant in his possession at the time of the arrest, but after the arrest, if the person so requires, the warrant shall be shown to him as soon as possible. So, at the time of the arrest of the offender, the officer must inform the individual about the cause of the arrest and the existence of a warrant. Even though the officer may not have the physical warrant on hand during the arrest, however, if the arrested person requests to see the warrant, it must be shown to them as soon as possible after the arrest. So, in first and second one, what's the importance of this? It's to ensure transparency and provides the arrested person with information about what's the legal basis for their arrest. And it also contributes to a fair and lawful execution of the warrant. So, when a woman or children are among the arrested suspects, the arresting officer shall task the WCPD officer of policewomen who is familiar with Women and Children Protection Desk duties to conduct pat-down search. So, when a women or children are among the arrested suspects, the arresting officer is mandated to assign this to Women and Children Protection Desk officer or policewomen with expertise in women and children protection duties to conduct that pat-down search. And the second one, in case of arrest without a warrant, it shall be the duty of the arresting officer to inform the person to be arrested of his authority in the cause of the arrest, except when he flees or forcibly resists before the arresting officer has the opportunity to inform him, or when the giving of such information will imperil the arrest. So, in instances of arrest without a warrant, the arresting officer is obligated to inform the person to be arrested of their authority in the cause of arrest, unless the individual flees or forcibly resists before the officer has the chance to provide this information, or when doing so would jeopardize the arrest. And the last one, the person arrested, with or without warrant, shall be informed of his constitutional right to remain silent and that any statement he makes could be used against him. Also, that he has the right to communicate with his lawyer or his immediate family, and the right to physical examination. The sixth one, a person arrested without a warrant shall be immediately brought to the proper police station for investigation without necessary delay. So, the person arrested, whether there is a document of warrant of arrest or if it is via warrantless arrest, they must really be informed of their constitutional right to remain silent, with a caution that any statement they make could be used against them. So they have the right as well to communicate with their lawyers or immediate family, and the right to physical examination. In the case of arrest without a warrant, the individual may be promptly taken to the appropriate police station for investigation without unnecessary delay. So this is very important, the fifth and sixth, because it ensures that individuals are aware of their rights, facilitating fair treatment and adherence to legal protocols during the arrest and investigation process. And that ends the discussion on Rule 113 about arrest. And if you have any questions, just feel free to ask me.